So I'll call the meeting to order. It's 1:09 p.m. right now. And we do have a quorum of members present. Oh, and I see Dr. Fraterelli has just joined too. Great. So there's 9 people now. Now, as we usually do, if anyone appearing by Zoom needs to make the disclosure required by HRS 92-3.7A, that is, if they're on Zoom and anyone's present with them who's over 18 or who's under 18 and has any business before us, please make that disclosure. Otherwise, you don't have to say anything. So I assume no one has to make that disclosure. Is that right? Okay, I don't see anyone saying yes. So, all right, let's move on to, we kind of have a lot to talk about today. So we had one action item, and I put this as an action item because it would allow us to take action today if we wanted to, but we don't have to. So we can't, I understand some people have to leave by 1:30. So if we just don't, have time to get to a vote, or if people think, we should have more people on board to talk about everything before we make a decision, that's fine too. But if we did want to take action on this item, we could. So the first item was kind of a report from the Legal Parentage Permitted Interaction Group, which I'm on along with Mark, Judge Hall, and Jerry, and Thad. And we'd been discussing kind of specifically the voluntary establishment of parentage section. And we wanted to ask the task force at large to weigh in on 2 different questions we had regarding the voluntary establishment of parentage process. So we had our report circulated ahead of time. Did everyone get a chance to download that or look at it? I can also share, well, yeah, let me try to, just for everyone's benefit, share the report on screen. Oh, never mind. I can't open it because we did not register Microsoft Word on this computer. So anyway, everyone, I hope has gotten a chance to open it and can look at it right now. But basically, we've been discussing the possibility of expanding the scope of individuals who can be eligible to voluntarily establish parentage. And any member of my PIG, please correct me if you think I'm misrepresenting something here. But under the current law, the spouse of the birthing mother, regardless of sex, as long as they're married, is presumed to be the parent of that child. So they don't have to go through this voluntary establishment of parentage process. They can just sign the birth certificate. But when it comes to unwed partners, only a biological male can elect to voluntarily establish parentage. And that male must attest that he is the biological father of the child, but he doesn't really have to do anything to prove it except to make that attestation. And then he becomes the legal father of the child. So we wanted to ask the task force to weigh in on the possibility of allowing a person of any gender to voluntarily establish parentage. Again, this applies only to unwed partners, even if they are not the natural parent of the child. So that would include, of course, same-sex female couples where they're not married, but the partner who didn't give birth to the child also wants to be a legal parent. So in our report, we first went through the pros and cons of doing that. And we can talk about that, about just that option first, like whether we want to expand that scope or not. And then if we are in favor of expanding eligibility, we listed 2 ways that we thought we could do that. And I wanted to point out that we're not saying that, assuming we want to go this way, we don't have to choose between those two options necessarily. We could also use both of them. So you could also have this, we could also just allow anyone of either gender to use the voluntary establishment of parentage process, as long as the birthing mother attests that she doesn't know who the biological father of the child is. And we could also have a separate uncontested court procedure that would kind of provide an expedited way if for example the birth mother does know that there's another, that there is a biological father out there, but that biological father is fine disclaiming parentage and allowing the other partner of the mother to establish parentage instead. So we could use both of the processes that we outlined in our report. So that was just a quick summary of what we already circulated, but I thought we could open the discussion on the first question, which is, is the task force in favor of expanding eligibility to voluntarily establish parentage in the first place? That is to allow people other than biological males who are unmarried to the birthing mother to somehow establish legal parentage through an expedited process.
And if I can just clarify, this would benefit a female same-sex couple, but it would not be of any benefit to male same-sex couple.
Right. Because the voluntary establishment of parentage process still can only apply when at least one of the people in the partnership is the one giving birth to the child.
Hey, Lauren, can I add one thing? And it's I think we didn't really discuss it in our PIG, but you noted that in the present process, the individual being added as the parent has to attest that they're the biological father.
Mm-hmm.
And I think in the present process, that's not necessarily true.
Okay.
That's what we I think it was intended to do. But when you read the VEP section as it currently reads, it doesn't specifically say it has to be the biological parent, and that's not part of the VEP form presently. Like there's no question that says, do you, if and only if you believe you're the biological parent, then you can be added on. So I don't think we brought that up before, but that's not, I don't think that's necessarily completely correct. So.
Right. And that kind of underlines I guess the way that the current process, isn't totally, like, it's not, it doesn't treat men and women equal, obviously, but it allows, anyone who's a male to basically sign on to be a legal parent, and he doesn't really have to prove that he is. But a female does, she's just, even though like a male, she might not necessarily be the biological parent, but she doesn't even get the opportunity to use the process at all.
I have a question. Did you guys discuss at all, or maybe this is just sort of headed into the weeds on this, but the interaction between that and the provisions that would govern assisted reproduction? Because if you have a female same-sex couple and one of them is pregnant, it seems to me more likely that she got pregnant by artificial insemination. And so we know, like, are you envisioning that her partner wife would be able to do an expedited process rather than the process as it would exist governed by the assisted reproductive technology? Got to keep in mind that there's laws about the fact that the male donor of the sperm that was used to create the pregnancy is not the father, right?
Yeah.
Legally.
Right. So we're envisioning this being separate from the laws governing surrogacy. So if there's a surrogacy, surrogacy,
It's not
or
surrogate. It's not a surrogate. Right.
assisted reproduction,
Yeah,
section.
assisted reproduction, right?
Yeah. So it'd be
Okay,
governed by
so
the-
then my next question becomes, and honestly, I just don't even know the answer to this, but do we know how frequently the situation that you're envisioning happens? Like, is it a hypothetical problem or a real one?
Well, which situation, I
Well, I'm
guess?
just using the, I'm thinking through the same-sex couple, two women, one of them pregnant, unmarried.
So the only way at this point, to do it, well, actually, if they're unmarried, there is no way that
Right.
the partner can be, because even the adoption laws, they would have to be married in order to do a step-parent adoption.
Right, a step-parent adoption, and then would there be, Judge, would there be a method, let's say that the biological mother who gave birth to the child, they live together, they operate as a family, her partner, the woman, the other woman, you know, is acting sort of de facto parent? Is there a way to establish parentage like through a legal proceeding that way, or could they do it, or they have to get married and that's the only mechanism?
There is a way to do de facto parent.
Right,
It is a more difficult process
mm,
and it's very rarely done, but there is the possibility.
right, okay. Because for me, it's a shame that Carol isn't with us today. I would want to make sure that she got the chance to weigh in on this because she has so much on the ground experience with the legal documents for her clients. But my thought is that I have no personal objection to expanding it. I just want to make sure that we're addressing a problem that really exists as opposed to a hypothetical problem.
So
Right,
this could potentially help with assisted reproduction, but we don't want to necessarily overstep actually creating rules and regulations on the assisted reproductions.
right, right.
This is Thaddeus. And Jeff, sorry, you can go first. I saw you raise your hand first. Okay, I'll just note, Deidre, I thank you for bringing that up, that I think the original intention of the bill that became the task force that became whatever it was that created this, was to address the needs of situations where there was, same-sex female couples who are unable to attest to parentage in an easy way, and that required a more lengthy kind of legal involvement. So from the community side, that was what we heard was the intention of putting forth this bill in the first place. Sorry, Jeff.
Okay, thank you. That's very helpful. So then one other follow-up question, maybe Judge Hall knows the answer to this one, is that if that is the method by which they establish the parentage, is it just as strong as if they'd gone through a more formal process? Like they have all of the rights, they have all the protections. It's not like a weak tea version of it, right? Like
The
they're
de
gonna get.
facto parent?
No, if you were to make something equivalent to an unmarried straight couple with the man recognizing that he's the biological
Oh,
father, you do the equivalent of that for our hypothetical same-sex couple,
Absolutely.
two women. They have all the rights. It's not like,
absolutely.
okay. Okay, thank you. Sorry, Jeff.
And then after Jeff, Laurel, I know that you had something to say too.
So this document was very well written and it's very complicated for me to grasp everything about it and all of that. I think that I might be the only person from the Birth Heritage PIG here, although I know Lauren, I can't see
Oh, Laurel's here with me, yeah.
Laurel. Oh, Laurel, I am so glad you're here. Okay.
Oh,
Then Laurel can actually correct me. But I wanted to express that I feel like the Birth Heritage PIG has at least some of us have an interest in what I see under the second pro number 3 about maintaining some kind of documentation of biological heritage so that that is not lost.
mhm.
And that's just the one thing that really jumped out at me is that I hope would not be missed.
Yeah, thank you. Yeah, that is definitely, I think, something we took seriously when we're thinking about how this would work. One of the cons I think you might note too is if you allow two, I guess two people, even though one of them, whether they're male or female, is not the actual biological parent of the child to become the legal parent, is that you risk maybe erasing the biological parent who does exist somewhere out there. And maybe, we just have to make sure that person, we do what we can to give that person notice, that person has some rights that aren't automatically just wiped out. So we have to keep that in mind too. Okay, sorry, Laurel.
No, no,
Go
thank
ahead.
you. No, no. And thank you, Jeff, because that was one of my questions. Thank you. Mark, I guess I'm going back to, I think Jerry was saying something about through the CSEA process, you have to try to find as many, how shall I put it, biological parents as possible because it's largely about funding, right? Is that going to get affected by this? She kind of made a big deal out of it, so I'm just wondering.
Yeah,
that
so
would-
it's not CSCA funding, but
Okay.
it's funding that's tied to temporary assistance for needy
Oh,
families. So
TANF.
the welfare funding.
Mhm.
So we have to, of the prior birth year, however many kids are born out of wedlock, there has to be 90% that have parentage established. And if we
Cool.
fall below that, then we risk losing funding. They would put us in a corrective year, and then
Mhm.
the year after that, you could potentially lose fairly substantial funding. And the large majority of our establishments come through the VEP process. So that is one of our concerns, is making sure that we don't create a process that somehow limits or reduces the amount of individuals that are able to utilize the VEP.
So we don't know if the feds, I don't know if Judge Hall would know this, but would the feds look upon this in a good way or a bad way if we
We
do this?
expanded.
Yeah. I mean, I don't know. I'm asking.
Yeah, I don't know for sure. I mean, my understanding of the reason they want to have paternity or parentage established is, lack of a better term, they have somebody on the hook.
Yes. Oh, yes. I understand.
So versus the government paying TANF, they want to make sure they have a parent that can either pay the child support to help support those children so they're not supported by government funds, or in turn reimbursing the government to at least a certain extent.
Right.
And this will not affect that.
Okay. Yeah. I just didn't know if they were gender blind or not. I don't know. That's why it's,
Yeah, that I couldn't say.
I'm definitely not the expert on this at all, but I had to go through our past meetings to kind of do our write-up about for the report to the legislature. And I think that Carol had kind of a similar question earlier, like when they do adoptions after assisted reproduction or surrogacy, is that going to affect the federal funding? And I think the answer was no, as long as there are two parents established, either through the court process or adoption or voluntarily. I think that was the answer, but again, that was just from watching our past meetings.
Yeah, so far we haven't had any issues with the same-sex marriages and having the same-sex spouse on the birth certificate. So
okay.
I'm hoping that we wouldn't have.
So I think when we talk about expanding the VEP process, I mean it seems like it would add the number of VEPs that we have. But I think one concern when I was chatting with Jerry earlier before this meeting that came up is that in its present state, like I had mentioned when I spoke up earlier in the meeting, there is no requirement that it be a genetic parent. But what we're looking at doing, and I think the intent of the VEP was that that it be initially open to a genetic parent. And if we add that requirement in, we could have situations where if that's added into the VEP form that they sign, if one of the things they have to attest to is that mother believes this is the genetic father and father believes he's the genetic father, we may lose some establishments that way. But I don't really know if there's any way around that. So.
Yeah, so
Okay.
are there any other, I mean, does anyone have a concern about expanding eligibility?
Well, I mean, I do have a concern if we're not collecting the information and documenting it somewhere, then I am concerned that we're losing genetic parent information, but that's been my consistent position, so I mean, that's nothing new.
Yeah, there were, oh, sorry, go ahead, Lauren, please.
Sorry, just very quickly from a procedural perspective, from a vital records DOH perspective, it's probably the path of least resistance. But I think the intent of the legislature, and I think the policy position of my department, is that if this is a part of a comprehensive constellation of ways that various couples can achieve parenthood, then it's fine. But we certainly don't want to exclude anybody who would fall out of eligibility for this straightforward process. So if it's part of the solution, from a policy perspective, that's what the department would support. Procedurally and process-wise, it sounds very straightforward. I don't think you'd have a problem with us from that perspective. So, Judge?
I was just gonna say, that's where we ended up coming up with a couple of different ways of accomplishing things, where either we add to the statute definitions of a professed parent, or we do a uncontested type paternity. And in the uncontested paternity, if there is some information as to who the biological father is, but they're not necessarily inclined to want to be part of the child's life, we could still have that information in the case file. So, I mean, that's kind of where we started talking. We came up with two different options.
So I know, Deirdre, you have to go pretty soon, right?
I can go another couple minutes.
Okay.
I-
I know Jeff already had to leave, so we might be dropping below our
Uh-oh.
one,
Oh,
two.
Well, I'll stay as long as I can so you don't lose
Okay.
quorum.
Oh, wait, Jerry's here.
Oh, wait, hold on. But I'm still gonna stay as long as I can.
Yeah.
Okay.
So yeah, like I said, I put this on the agenda as an action item in case we do want to take a vote on it, but I'm kind of leaning towards just continuing the discussion right now, because it seems like, most people who are here are from our PIG anyway, so we've already had this discussion. But yeah, and then we would I would want to have, like, the other members who aren't present to kind of be able to weigh into. But so anyway, we can keep discussing, Deirdre, and if you have to leave, you do whatever you need to do. But
Okay.
I don't think I'll be taking a vote on this right now, but let's continue to talk about it. So
Well, for myself, I would want to see the proposed amendments to the statute, like how you're actually going to do it. Because I think conceptually I'm good with it, but the devil's in the details.
Yeah.
Right.
So I would want to see, like, how are we going to address the concern that we seem to be in agreement about? How do you preserve the genetic information of the genetic parent in this situation? And I'm not really sure exactly what the answer is with that. So for myself, I would prefer both to continue it and also that we wait on, like, a vote of what to do. I can't tell you whether I'm for or against a statutory amendment till you show me the statute.
right.
Right,
Yeah, I
yeah.
think the vote is more for us to get,
Right.
for you guys to tell us what to do, because we started looking at drafting actual language, and we're like, we can't really move forward, or we would take a lot of time maybe working on something when maybe people really don't want us to go in that
Oh,
direction.
I see. Okay, so you're just considering incremental, right? Yeah, like whether you should go ahead and draft statutory amendments that would accomplish this, right?
Right,
For the full task force's consideration. I'm in favor of that.
Mhm.
If other folks are okay with that process as well.
Yeah. So I guess, do people have thoughts on the two options that we presented? Like I said, one would be to just kind of use the process we already have and just basically say, it doesn't matter if you're a man or a woman or non-binary or anything. You could attest to parent, or you could, legally, voluntarily establish parentage. But that would only occur as long as, or we'd only allow that, I guess, as long as the birthing mother doesn't say, I know who the biological father is and I can identify them. And that, yeah, again, like
Kind
Deirdre
of a
pointed out,
tangled web.
yeah, it doesn't, that doesn't really,
I don't know
it
about
doesn't seem
writing
like,
that.
yeah, it's not
Good
gonna
luck writing
apply.
that statute. I don't.
It's not going to apply to a ton of people because it would, you know, it would really be situations where you have, you know, two unwed partners where the birthing mother is pregnant by someone else, but nevertheless doesn't know who that is or doesn't want to say who that is, and their unwed partner is still willing to parent the child. So I guess it wouldn't apply to a ton of situations, but it would, you know, make things equal between biological males and everyone else.
So is that the way the attestation works now for a straight unmarried couple?
So right now, the way it says is that mother says, yes, I believe this to be the father. Father says, yes, I believe the father, I'm the father, and I don't need a genetic testing.
I see. So
Essentially.
we can't really make that entirely equivalent, right? For a same-sex
No.
couple, that's not gonna work. Okay.
Are you, excuse me, are you talking about the VEP process itself, or are you talking about the judicial process?
The
The
VEP.
VEP.
Yeah.
Yeah, I was just wondering, just as a sort of the starting line, how does it work now for a straight unmarried couple? Like what attestations do they have to make? The woman who just gave birth and the man about their knowledge or expectation about his genetic relationship, right? And so I'm just trying to figure out if there's a way to use that. But it seems to me that attestation isn't going to work, right, for a
Yeah.
same-sex couple.
Yeah, so the attestation would have to be, I don't know who, or it, like, assuming it's, you know, someone who cannot possibly be the biological parent of the child, the mother would have to say, I also don't know who the actual biological parent is. And if she does, then the only way to establish parentage between her and the unwed same-sex parent would be to go through, I guess, adoption or the court process. And if we go through the court process, we propose this possibility of making it easier, assuming that you have that the absent genetic parent, I don't know if that's the right term for it, but, you know, the biological parent who wants to give up their rights is willing to sign on and willing to just let the unwed partner become the legal parent instead. So Judge Hall kind of explained it as almost like kind of based on uncontested divorces, sort of.
Is there any reason we couldn't make both of those options available?
No,
as opposed to
that
an
is
either or, right?
Right,
Because it's
no.
right, because
can do
I confess as a lawyer, I liked the idea of the, you know, prepare all the forms, give the judge the judgment method, right? Because you would have the benefit of all that process that would be there. But it seems to me you could hopefully make it more streamlined than it would otherwise be, right? So
Yeah, we could
I'm
definitely
assuming that doesn't exist currently for unwed straight couples.
No, not at this time. It wouldn't be that difficult, I don't think, to do. It'd be a matter of maybe changing some portions of the statute and rules, and then of course having to create forms.
Right.
Lauren.
Yeah.
I hope this is relevant, but you know, there's been a couple cases, not in Hawaii, a couple other states where unmarried same gender couples, I believe it was both women, they did not marry and they did this voluntary kind of parentage thing, but then there was a custody dispute. I believe the courts ruled that actually they should have gone to an adoption. There should have been a judicial process. So, you know, I think about that and I don't know, maybe that wouldn't happen here. And I know laws are different in different states, but I understood why, the little bit I read that I could understand on the case, why they would say that. Because this voluntary attestation I don't think it's even quasi judicial. I may be wrong about that, but so, you you know, there are reasons to have judicial processes, and if we do an expedited one, I think that might be better in some of these cases, but that's just, you know, I don't know how far these went on appeal. I think one was Kansas and it was in the Midwest somewhere. That's all I can remember.
So
Yeah,
the closest thing I know of here was actually a married couple, same-sex couple, where the wife, the non-birthing wife, was trying to not have, you know, like I said, get off the hook. She didn't want to have to
Yeah.
pay child support.
Right.
And so she was trying to say, well, I'm not the biological parent, so I shouldn't have to pay child support. But the appellate courts said, no, sorry, you are the spouse, and by law, it says the spouse is automatically the legal parent.
Right.
That's the closest thing we have.
yeah,
Yeah, but they married, and so I think when we're talking about unmarried
Right.
situations, that's what I'm a little
Yeah.
nervous about.
but if we make a statutory change, it would be like, as a matter of law, you are the parent if you voluntarily establish
Fine.
yourself
Okay.
as such.
Oh, okay.
Yeah,
Okay.
And that's
it
how,
wouldn't be a presumption at that point, I don't.
no.
Okay.
Yeah, you would be legal parent at that point.
Okay. Okay.
And it's the same how the current VEP process works. There is no genetic testing, there's no confirmation that they are truly the biological father. They are just saying that they wish to be the legal father.
Mhm. So in practice, I mean, I guess there might not be data on this, but in practice, you could have lots of men who don't really care if it's their biological parent or child or not, but they're, you know, they're the partner of the woman giving birth, and they say, I want to parent the child.
That actually happens more than you might think.
Yeah, I bet.
Okay.
May I say something with regard to sorry, this is Jerry, the VEP process? You know, I've been involved with it for many years, but the feedback when we have our training, which is every 2 years, is that we're looking at the biological parents in terms of who is signing the VEP forms. The forms are not only the brochures are given, but the information provided is it assumes, but it also states that you have a responsibility, and I think it is not only as far as the undertaking, you know, it is a legal obligation when you do assume this responsibility, but also there are benefits. And what I'm hearing from the medical providers at the birthing centers is that they are dealing with the biological parents, the mother and the father. And if it is not, it is a rare situation.
Mhm. Yeah, that makes sense.
I would
I-
expect statistically that would always be the case, right?
Right.
But it doesn't, but there's nothing about expanding it that would weaken it for straight unmarried couples, right? They could still use it.
Yeah.
So, you know, I don't think it would be made different. The forms would have to be changed after the statute was amended, right? To make it so it fits whomever is reading it, right? But
Okay, so like, and I know that I think you had to leave by 2, right?
Yeah.
Yeah.
And I just wanted to add to that, like, I mean, and we had discussed this, I think, before, but what Deidre had mentioned about, you know, it's not an either or option. I think it's
Uh-huh.
really important for us to remember too, like, it
Mhm.
just might be helpful just to have both pathways, if there are challenges with one or the other.
Yeah, even if the first one might not get used a lot, it, you know, it does make things a little bit more equal. And then having the court process is kind of more of the catch-all. right?
No, I agree. I like the idea of having, sort of the streamlined formal option and then the, the most streamlined option, which is just the form, right? And expanding access to both of them. And I would say that, as long as it's something that the community feels is necessary, I don't see any reason why not, but I would want to see I think some of this language is going to be pretty hard to write. That's what I
Yeah,
think.
yeah.
The writing the amendment is going to be pretty challenging, but that's kind of where I landed on this.
Okay. I mean, okay, so it sounds like we're all, generally in favor of at least trying to explore the possibility of using these two options, right? I don't think we need to take a vote necessarily on it. I think maybe our pig can go back and maybe elaborate, try to put some flesh on the bones of the processes we're thinking about and bring that back and see if, people are okay with what we propose, but at least we kind of have some guidance. So yeah, I don't think we need to necessarily do a vote, but anyway, before I move on, I know we're a little short on time. I know before we move on to the updates, I guess I'll ask if there's there's no one here who would present public testimony. And Brandon, there's no one in the waiting room, I presume.
Just Kaliko.
Okay. All right. So, all right, I'll move on from item A1. Was it A1? B1. I'll move on from that. We'll go to the updates from the rest of the pigs before we lose quorum here. So, item C1A, status update and reports from the legal parentage pig. So basically what we already just discussed is kind of our big update. I don't think we have anything really else that we need to get input in on this time, and or any other updates we need to share besides what we just talked about. We'll be revising, I guess, or we can work on some revisions to the draft bill, or at least some more detailed outlines based on today's discussion. But does any other member of my pig think that we need to discuss anything else? Yeah. Okay. All right, so then I'll ask the birth heritage pig for any updates. And I know that you guys shared the meeting notes from your latest meeting that was in November. And before we hear from them, I think this is relevant to the birth heritage pig and for the rest of the task force also. But I got word that the Uniform Laws Commission, the subcommittee on gamete identity disclosure or gamete donor identity disclosure, they've apparently finished drafting suggested amendments to the 27 UPA, which of course is the document that our draft bill that we're working on is based off of. And so as soon as that's publicly available, I can share that with everyone. And I think that would be particularly relevant to the birth heritage pig, but definitely for all of us. So look for that before the next meeting. But okay, with that, I'll ask if anyone from the birth heritage group has anything to share.
Lauren, it's you or me.
I will just be reading off of your notes.
Oh, okay. Okay, well, first thing, I have to actually correct the meeting notes because I left my own name off, which is pretty hilarious given the fact that I drafted them. So I need to amend the notes to say that I was present because I don't think I put my name as the. Okay, other than that, I really wanted to thank Lauren for bringing in the vital statistics folks because it really, really helped me. And I think it helped Jeff, and I think Carol probably knew more, but Jeff and it helped quite a bit, Lauren, so thank you. And I think everybody kind of understands that, yeah, vital statistics has evolved over the decades, and birth records are viewed from different perspectives, I guess, depending on which your chair you're sitting in. But I think DOH sounds like they're open to working with however we can craft something to perhaps try to preserve some information. They do have a process already through adoption, so that's why, at least from my perspective, it's kind of there. And they do the best they can. Their full disclosure was, we can only do what people are willing to share with us. But I think Carol would represent that she tries hard as a family law practitioner, and I'm sure the courts, when necessary, can remind people of their obligations. So I think it was a fairly positive meeting. There were some things we wanted to continue to, I think, talk about on the last page in item C, about how, again, we're sort of, I think, in the same position as the prior group that just reported. We wanted to try to figure out how to write some of this. Again, for me, I would maybe refer back to the adoption law, although I do agree it probably could be updated. It's a little lengthy in some places. But again, being mindful that if we're going to keep adoption separate from ART and surrogacy, and then maybe some of this voluntary parentage, it's going to get kind of tricky. And I can see Judge Hall probably getting a headache trying to figure out all the different pathways to parentage. But I think we probably will need a meeting or two. Our mental health professionals wasn't able to join us, and so I'm hoping when we have our next meeting, she can join us. I'm going to try to connect with her and see what's best for her, so we can kind of make some notes about that as well. What I was reminded of when we were in this meeting, and what I always try to bring forth to the task force is, adoption was established because there were needs. Children needed homes. Warehousing children in orphanages was not a good thing, probably. And families were dispersing. There was no fostering. We've come to the place now, though, I think, with adoption and then with ART, now we're dealing with adults' needs, maybe, or wants, maybe more wants to be parents. And so I look at it through those two lenses. And I have to always come out on the side of the child, which is, okay, well, we're creating children so people can be parents, but there's still those needs there. The child's needs maybe will be taken care of. They'll hopefully be loved and be sheltered and be fed. But there's still those emotional needs, perhaps about genetic background, birth heritage, and certainly healthcare, that I think I still would like to keep in the forefront as we do our work on this. So our group seems open to doing that. So I just would open it up to comments about that, or suggestions.
Yeah, I have a few. Sorry, I'm just going to jot something down really quick. So on the first page, it mentions that DOH also issues amended Hawaii birth certificates in certain situations. One was upon written request to DOH from a birth parent with required documentation. And I was just wondering, and maybe this is a question for Lauren,
Yes, please.
like what are the circumstances under which a birth parent can request an amendment to a birth certificate?
Generally, if it's a correction that can be substantiated. So our office assistants apply administrative rules, and it's usually correction of incorrect or erroneous or outdated information. But there is a level of evidence that they need to meet. You obviously can't just come in and say, I just discovered I was Hawaiian and amend my birth certificate. So usually it's time and place, or something that happened as a result of data entry error at the birthing center.
Right.
Less less frequently, less commonly is it something that substantive. As in, I thought I was Chinese and now I'm Chinese Hawaiian.
And it's not gonna be like the identity of a parent, right? It wouldn't be like, I thought this guy was the father, but it's actually this guy. Or could that be one of the circumstances?
If that came in, that is something that we would only change as a result of a court order.
Okay.
You don't want the department making that determination,
Yeah,
that
yeah.
finding of fact. So I'm sure it happens, but that's not something we'd say, okay, yeah, we agree.
Yeah,
You guys have the same nose, right? Or something.
Yeah.
So that would come in through the courts.
There is
that's-
one minor exception, I think, and correct me if I'm wrong on the number of days, 60 days after a VEP, a parent can withdraw.
yeah.
I don't know if
Yeah.
that number of
The-
days, right?
Yeah,
So would they-
the cold feet
Yeah.
escape.
And then
Escape
does that request go to DOH or does that go to the courts to withdraw? I'm sorry, I should know this
I
too,
believe
but
that's DOH.
I think so.
Yeah, the rescission, excuse me, the rescission is a document which is kept by the Department of Health in Honolulu. And the parents must make the request within 60 days to the Department of Health to have the rescission executed and delivered to the Department of Health.
okay, and then I had another question. So on the last page, when you guys were talking about topics for further discussion, and one of the things was possible statutory language requiring DOH to retain donor medical information and family history. So I guess this is another question for Lauren. Like, is DOH, would they be okay with that in theory, or do they, are we're just not sure what their capacity or what their willingness would be to keep the records at this point? All right,
What
so I
happened?
don't see Lauren. Maybe that.
There he is.
Would have to be-
I'm sorry, I heard you talk about the
Sorry.
department's willingness to open our statutes to authorize or permit the collection and retention of certain information that we do not.
Yeah, like, are they willing to do that, to retain all that information?
Conceptually, yes. We are always looking for as complete a record as possible for posterity. We haven't thought through the logistics or the costs, but I think it makes sense to have a complete set of vital records as possible. So we are definitely open conceptually to that.
I think we talked about that in our group too, right? I think Thad, maybe you had asked DOH about this, like if we, do this expansion of voluntary paternity, if DOH would still be willing to keep records of, the genetic parent who decides not to assert their parental rights.
Yeah,
Yeah.
I mean, we already have sealed records, records and sealed records for adoptions.
Mhm.
We probably need to, once we get in, like was said earlier, the devil's in the details. If it's collecting for everybody, then that needs to be an upstream change, probably. But if it's sort of case by case or non-routine, for example, adoption, something that requires the judiciary or another process, we're collecting information, we're sealing records anyway, so I don't think it would be an additional burden. So I think the use case will depend, our level of support will depend on how many records would be subject to the collection and retention of additional information, but certainly for the purposes that I think are in scope for this working group, yes.
Okay.
Oh, so
Oh, no, go ahead.
I just had and Dr. Fratarelli's been on and hasn't had to answer a question, but I'm gonna ask him. Do we have any idea what percentage of births in Hawaii are ART or surrogacy? Or would we know, or how would we find out?
Yes, just trying to make sure I unmute myself. In general, across the country, it's about 2% of births are from ART. And I think that in Hawaii, it's probably going to be the same, somewhere around that 2 to 2.5% range.
That's great. See, that's a population, at least in my mind, we're thinking about.
That's more than I
So
could
that
think,
doesn't sound like a
actually.
huge workload, but maybe I hope I'm not misspeaking, so I'll be careful, but thank you, Dr. Federer.
Yeah, thank you.
I mean, I actually would add too, though, that percentage will increase as more people are using ART, you know, the same-sex couples, single patients. So that number will continue to increase as time goes on.
Okay.
I think it's gonna be important to hear or get to see what the Uniform Laws Committee comes out with. Because, from what I've heard, I haven't seen anything yet. They may want to make it more kind of like the adoption statutes where the genetic information of a donor is kept somewhere that a child born of assisted reproduction would be able to access after they turn 18.
Wow, that'd be
Yeah,
great.
I think that is, from what I've been told, I think that is what the revision will be like.
Well,
So that could have a drastic effect on things. Because that could actually make it easier for our process of thinking how we want to do it. And maybe they'll actually write some of the statutory language for us so we don't have to think so hard.
Yeah,
So Lauren, the latest I can absolutely stay is 2:15, which I think is gonna cause you to lose your quorum, so,
okay, well, yeah, we'll try
and-
to,
yeah.
I'll try to, okay, so does anyone else have questions for the birth heritage pig right now? Okay, well, with that, we'll move on to the sorry, did you have something?
no,
Laura?
thank you.
Okay.
Thank you. Thank you, Lauren.
We can move on to the assisted reproduction and surrogacy pig and see if you
Well,
guys have any updates or.
Dr.
questions.
Fratarelli, did you want me to give a summary of our meeting with Carol, or did you want to go first?
I will let you have the floor.
Oh, okay. Yeah, so we had a lengthy meeting. Not everybody from our pig was able to join. I don't have written notes to circulate yet because we just did it a couple days ago, but it was very helpful. We discussed the portions related to surrogacy and assisted reproduction at considerable length. Most of the things that we're thinking about are additional definitions, clarifications, wanting to see how they interact with other provisions, not sort of, you know, conceptual changes. We had a lot of questions about some of the terminology, and Carol and I also got a lesson about the difference between a zygote and an embryo. Anyway, we did cover a lot of ground. One issue to flag for you, this isn't for the purposes of discussion today so much as just to let people know that we were thinking about it, is that when we looked into the uniform laws, when I was looking at the 2017 law from the Uniform Laws Organization and its commentary, it turns out that the states that have enacted statutes about surrogacy have done so only for gestational surrogacy, not genetic surrogacy. So our current draft includes both. So the big global question is whether we would want to permit both. Dr. Fratarelli explained that genetic surrogacy, meaning that the woman is biologically related to the child, but is not intending to be the child's parent, right? Apparently it doesn't happen much. That's like the old fashioned or quote traditional surrogacy, which I imagine happened before the technology that was available now that would allow a woman to carry a child through pregnancy that she's not genetically related to. That technology didn't used to exist, right? So in any case, that was one big question. You know, the thing that was so interesting when we were discussing it is I actually looked up the comments from the uniform law while we were in our meeting, and the thing says that the states only permit what's called gestational surrogacy, not genetic surrogacy. So there was some conversation about whether genetic surrogacy should be addressed at all, whether we might even want to just say we're not doing genetic surrogacy. And part of the reason why, and I certainly understand this, is the potential complications involved with basically a woman agreeing to carry a pregnancy for the child to whom she is biologically related and ostensibly committing to giving up that child. You can just imagine the complications that come from that versus I can easily imagine the considerable sacrifice and effort involved to agree to gestate a baby for someone. But if you're not, it's not your child genetically, then I think that's a very different decision. So that was kind of the biggest global thing that we talked about. Most of the rest of the topics were like puzzling over, the lining up different provisions or the definition of the word record. Then there were medical things that didn't quite fit according to Dr. Fratarelli. So our next intended step was we were going to pull out that section and start to try to put together a red line based on our conversations just within our group. I don't think we're at the point of sharing it outside the group yet, but that's kind of where we were at. So we did cover quite a lot of ground. There was a lot of discussions about, how these provisions will actually work, meaning what does a surrogacy agreement actually look like? What does it read like? What provisions have to be in there and which ones are optional and all that sort of thing. So we did make a lot of progress, but the other groups are ahead of us. I don't have anything in writing to give you yet. So.
Well, thank you.
Yeah.
Well, that's really interesting. So yeah, I just thought, I thought maybe genetic surrogacy would be kind of common, like especially if you have two males, I would think like it might
No,
be.
a male can't be a surrogate.
No, yeah, but for two
Yeah.
males to have a child via surrogate, I would think that it'd be easier for them to like use that person's egg rather than like get another donor and use her egg and then put it in a third person and have her be the surrogate. But I guess that's still.
Well, certainly you're correct. There's another person involved, but apparently according to, Dr. Fratarelli can explain more of it. Apparently, a surrogate with a genetic relationship to the baby is uncommon these days.
Yeah, it just very, it complicates everything, as far as, the whole process. And again, it's just it's a big step for somebody to have a pregnancy and then give it up when they know it's biologically theirs. And there's been a lot of trouble in the past. So, the unknown donors, it just makes it a lot cleaner for people. And we find that there are very few people. I mean, once a year, maybe we'll have a request that will look into that. But it's generally very easy to talk them out of it. And I think that across the country, there certainly are, many states that don't allow it, where it's illegal to do. And most of my colleagues, I don't really know any colleagues of mine that actually do it, or at least they don't profess to doing it.
Well, see, that was the part that was so interesting to me, was what Dr. Fratarelli is explaining is like what's best practice on the ground, right? And that there's psychological complications and considerations that are avoided by using a surrogate who is genetically unrelated to the child, right?
Right.
Yeah. So anyway, I thought that was very interesting. That was definitely the biggest sort of global question that we were discussing, and that you could basically, if you look at those sections, what you see is there's a huge degree of overlap in the statutory language as we have it, the draft, where the same provisions would govern both gestational and genetic surrogacy. And then there's an additional level of protections for genetic surrogacy because of the acknowledged additional complication of the genetic relationship, right? So anyway, what we wanted to do for purposes of this meeting was just to flag that big global issue came up, because it would be an overhaul of the draft. Because if you decided that we should not permit it, you could outlaw it in a single sentence and then delete many provisions of the draft, because you basically would make it so that the surrogacy that's legal under Hawaii law would be gestational. Yeah.
I know, Deidre, you got to run.
I do. Yeah.
But see, what I'm hearing is what used to be what adoption was, interfamily adoption, basically. So it's interesting, and I'm kind of a little relieved when Dr. Fratarelli says it's really probably not PONO anymore, because it causes a lot of problems. And that's where a lot of the secrets were held, right, in these interfamilies. But, we do still have Hanai in Hawaii. So I just want to make sure we're not going to somehow erode that, because that is for Hawaiians, an appropriate way of having a family. So I don't know, and it's not written down anywhere. So I'm just cautioning that, and I don't even have an idea of, I mean, maybe saying nothing is better, but.
No, that's a fair point. I mean, that's why we didn't really try to make a decision about that big question about, whether to, to include genetic surrogacy, whether to, you know, include it at all, whether to ban it, but that's a fair point, right? And I think there are very different like cultural expectations
Yeah.
about, you know, your genetic relationship to your child. And I get what you mean about the, you know, the secrecy about adoptions and, you know, your niece who's really your daughter, that kind of thing, right? So.
But even if we
Yeah.
said you can't have a genetic surrogacy agreement, I mean, functionally, like you could still have a woman who decides to undergo like assisted reproduction for herself and then decide to adopt out that child to a couple who wants to adopt it. Right? It would just go through the adoption process and not through like the laws about surrogacy, right?
You could. I mean, the other thing too is just to keep in mind the, you know, as we all very well know, making something unlawful does not necessarily stop it from happening,
yes.
right? So, so I think I myself would be very much inclined to take the path of least resistance on this, you know, because the bill is going to face some significant challenges and we want it to succeed, right? And to try to achieve its results, you know, overall with, you know, what's the best fit for the most number of people and, you know, politically palatable, you know, workable as policy. And then, you know, we need to know that if it's better to regulate something than to leave it unregulated, that would be a fair conclusion as well,
Mhm.
right? So,
I was hearing that now. I mean, I personally would probably lean towards not including the genetic surrogacy and just staying quiet, essentially. Not saying that it's illegal or anything like that.
You don't
But
regulate.
there can be other methods to do it. But we just don't make a specific law allowing it necessarily.
I see. So
Yeah.
then what that would do is if you look at the draft, it would focus the surrogacy laws on gestational surrogacy and be silent as to genetic, just mum's the word,
And-
right?
Okay.
And I can say
Yeah.
that, you know, I've done IVF for 30 years. I know I practice in, you know, DC and Maryland and New Jersey and here, and I've never done a genetic surrogate cycle.
Wow.
I've had a few people ask, you know, 5-10 people ask, but I've never done one, and I don't know any of my colleagues that have, but I'm sure it's done. It's just very covertly, and then patients can still get around it if they wanted to. And I was mentioning, you know, you could have a same-sex male couple come in, but not the couple, but have one male come in with the other person's sister and profess that they want to do IVF. We
Yeah.
don't ask for proof that they're a couple. We do IVF on them, and then, you know, whatever happens after that is up to them. But so it still could happen, but not, it wouldn't necessarily be regulated.
Right.
Right. And then what you're describing is IVF, not surrogacy, technically,
Yeah.
right? Yeah,
And
because
like
she's,
and then she could, and then the same sex husband could adopt the child after, as long as the
Right.
mom is like,
Right. The
Right.
sister would be carrying the pregnancy for the
right. And
brothers.
so her niece would be her biological daughter, basically, right? In the hypothetical
Right.
you're imagining.
Right.
I could, depending on the family relationships, I could imagine that working. I could also imagine it really not working and causing
Right.
all kinds of problems. But in any
5 years
case,
later, it could be a nightmare. Right.
yeah, exactly. Right. But I think I very much would want to just keep our feet on the ground about this, you know, in terms of eye on the ball. We can't possibly address every soap opera scenario that could come up, that people can come up with in this area, right? So.
does anyone else have questions? No? Brandon, I assume no one else wants to, no one in the gallery has raised their hand or anything?
Correct.
Okay. So for all of the pigs, you know, if you do want to bring something to the whole task force for discussion, like we just did with the legal parentage group, just let me know, and if you can help me like write the agenda item to, you know, the language that should go into the agenda so we know what's coming up and what we should be thinking about. Let me know, and if you have material to circulate, we can do that too. But yeah, otherwise I know that Deirdre has to go, so I will
2 minutes.
adjourn at 2:13 right now.
Okay.
And yeah, let's try to set another meeting, you know, as soon as we can within February, hopefully to get more people on board, and by then hopefully at least our PIG can maybe get some more concrete details to people. So yeah, anyway.
I wanted to make one suggestion, basically, because I almost did this, is that I miscalendared this meeting because I don't think there was actually a calendar invite from you guys, because the Zoom links are all separate.
Yeah, the Zoom links are different.
Yeah,
right?
so you could do a calendar entry without a Zoom link. Because otherwise what happened is I put it in the wrong place and it was just happenstance that I figured out that I had
Oh
it wrong.
no. Okay, yeah, I'll
Yeah,
that's a
and
good
then
point.
maybe you could ask Derek or Tammy to remind us the day before. You know, it's a big group. People are so busy.
Sure.
You know, and since we depend on quorum, that might be really helpful.
Yeah.
You know, be a little bit of pests about it. I know I'm inviting additional emails. And then my only other suggestion, Lauren, would be is that as we move to more substantive discussions with the, you know, the pigs coming out with, you know, substantive, you know, debate on different points, that we need to be realistic about how long those meetings can be. And one major topic, that's it. We're gonna have to, I wouldn't be able to meet for 4 hours, but I could do multiple meetings of 1 hour, right?
Yeah.
Yeah.
Okay. Well, yeah, if people, you know, if we want to meet, if we want to try to meet more frequently, we could do that too.
I just think we just need to wait and see what happens with the pigs coming out with, you know, proposed amendments to the draft, right? And then we just need to be really realistic about how much of that can be covered in a meeting, because, you know, we all have so many other things scheduled. So,
Mhm.
yeah.
Okay, thanks. Yeah, thank you for
Yeah.
that. All right. Well, thank you everyone for your time. Hope you had a good new year. And yeah, if you have any questions, let me know, or let Derek know. And otherwise, we'll do the same thing, try to find out everyone's availability and schedule another meeting.
Oh, look at Lauren says things not in Outlook do not exist.
Yeah.
That would be me figuring out that I had to make my own calendar entry and then paste the Zoom link into it, right? You need to make it stupid proof, okay? Speaking for myself only.
I'll make a note of that too.
Yeah, okay.
Thank
I
you.
know the Zoom links are separate because of the way the panelist thing works.
Yeah.
But even just a calendar entry that says you're gonna get a separate link in it would be helpful.
Okay.
Yeah.
All right. Good to know.
Cause I
Great
was like,
discussion,
kind of,
great
where's the
organization,
link?
guys. Yeah,
Yeah.
thanks, everybody.
Thank
Yeah.
you.
Thank you. Thank you
Next
so
time.
much. All right. Bye-bye.
Bye.